Hi again, Jonathan Ratchik. I'm an attorney at the law firm of Kramer, Dunleavy, and Ratchik in New York City. We are a full-service plaintiff's personal injury law firm. And one of the questions that I and probably all plaintiff's personal injury lawyers get, one of the most common questions is, after a case is over, when do I get paid? When do I get my money? And this is an understandable question, right? A settlement or perhaps a verdict was oftentimes the result of months, if not years, of litigation, negotiations, and certainly not a small measure of patience. But before settlement proceeds can be distributed to a client, there are oftentimes things called liens that need to be resolved. Okay. And today I want to just explain briefly what liens are, the different types of liens that are out there that can come up in personal injury lawsuits, and why they need to be paid, and why paying them can oftentimes delay issuance of a final settlement check. So in its most basic, simple terms, a lien is a legal claim against your settlement proceeds. Okay. It usually comes from a governmental agency or perhaps an insurance company, and someone who paid benefits on your behalf, medical treatment on your behalf, and is looking to get reimbursed for those benefits out of your settlement proceeds. Okay. And how that affects the bottom line is that the gross settlement amount, even after attorney's fees and attorney disbursements, is not always the amount that you are going to walk away with at the end of the day. Okay. Because before the attorney can release the settlement proceeds to you, an attorney must first account for and pay any valid liens against your recovery. Okay. And again, this does not mean that every lien is valid. Okay. Some liens are valid, some are not. And sometimes liens might include unrelated charges for unrelated medical treatment or unrelated medical conditions. And sometimes there's a dispute as to whether the lien is enforceable at all. But if it is valid, and if all of the charges that comprise the lien are related to your claim and the injuries that you're alleging, they have to be resolved before your proceeds can be distributed. Okay. So the common types of liens that are out there, the big one is Medicare. Okay. So if Medicare, anyone over, I think the age is 65, if they pay for any of the treatment related to your injury or your claim, they have a statutory right to be reimbursed for those benefits that they paid. Okay. These are what they call conditional benefits, right? So it means if it's on the condition that they will have to be repaid if another party, such as the defendant or its insurance company, has to pay you for that claim. Okay. And these claims have to be handled carefully, because if Medicare has a claim and it's not paid, guess what? They're going to come after the lawyer, okay, for those benefits that often have been paid. Okay. And certainly a lawyer does not want to get sued by Medicare for benefits or for a lien that ostensibly should have come out of the settlement proceeds. Okay. And it takes time. First, a claim or your case has to be reported to Medicare. Then they have to go through your charges and come up with a conditional lien amount. And then even after a case is settled, you have to report the settlement with all the expenses. And it is a time-consuming process to get a final lien amount from Medicare. There are also Medicaid liens. And again, the same thing. Medicaid is a public benefits program. And if someone is on Medicaid and it pays for treatment related to your case, Medicaid is going to seek reimbursement for those benefits paid. Okay. And whereas sometimes Medicare will reduce its lien, I think Medicare oftentimes reduces it by a third plus whatever additional percentages for comprising the costs and the attorney's expenses. Okay. So, but say anywhere from 33 to 35%. I don't think that Medicaid usually does that. Medicaid wants to get reimbursed in full for the benefits that it paid on your behalf. There are workers' compensation liens. Okay, so if you were injured on the job and within the scope of employment, and you received workers' compensation benefits, the workers' compensation carrier will assert a lien against your lawsuit. Okay, and what's important is that, again, workers' comp, before you can even settle your case with a defendant's insurance company, you need to get written permission from the workers' compensation carrier to accept a settlement in a third-party lawsuit. Okay, if you don't do that, you run the risk that there might not, because you have to protect workers' compensation's interests. Okay, and you cannot accept, for example, an offer that might not be sufficient to fully satisfy workers' compensation, the carrier's lien. Okay, so it's important that you get their written permission to settle the third party action. And hopefully there's enough money there to pay off their lien. And if there's not, then perhaps the attorney can work something out with the workers' compensation carrier to perhaps accept something less than their full lien amount. Okay. And there's all sorts of calculations that go into if you settle a case, then you might take a comp holiday. And again, there are specialists who deal with just resolving workers' compensation liens and working that out. And that's not me, but these are liens that do need to be paid out of your settlement proceeds. Okay. And lastly, there are private health insurance liens. Okay. So oftentimes when you enroll in a private health insurance plan, you will get a summary plan description, which is a big fat book that you probably put in your filing cabinet and never open. But within that book is a subrogation provision, okay, which basically means that the insurance company has the right that if they pay benefits on your behalf and you bring a lawsuit against a third party, that they can seek reimbursement from you for the benefits that it paid. Okay. And if you don't pay these benefits, if you don't pay this lien, they could withhold benefits in the future until such time as you've satisfied the lien amount. But again, these are liens that may or may not be valid. Okay, so it is important to speak with your lawyer to determine whether or not you do have to repay them. And again, I can talk at length about which ones do and which ones don't need to be paid back, but it is important to recognize that you might have to pay back your insurance company for any benefits that it paid on your behalf that are related to your lawsuit. Okay. Again, because the law both the law for the statutory liens and contractually give the lien holder the right to reimbursement. Okay. And so if a valid lien is ignored, there can be serious consequences. Okay. The client or even the attorney, they can be pursued for reimbursement or for repayment. Okay. The attorney can get sued for repayment, or the insurance company can cut you off, or whether it's private insurance or workers' comp, they can cut you off for future benefits because you haven't paid the lien back. Okay. So it is important to identify them, to know how much they are, and to work with the lawyer in getting them resolved the right way so that it doesn't create headaches down the road. Okay. So, and what all this means at the end of the day, okay, is that after a case settles, clients, mine, anyone else's client, they're eager to get paid. But lien resolution can take time, weeks, sometimes even months, right? Because you have to write to the lien holder after the case is resolved to get a final lien amount. And that can take a long time because guess what? The government agencies are strapped for personnel, and there are lots of claimants out there and really not a whole lot of manpower or women power for Medicare or Medicaid or whomever it might be to figure out what the final lien amount is. Okay. And until the attorney gets that final lien amount, the lien can't be paid. Okay. And there's really not a whole lot you can do other than just being a real pain in the butt and a squeaky wheel to get that final lien amount. And again, this holds particularly true for Medicare and Medicaid. They are just overwhelmed with, there are just not enough people resolving these types of claims or these types of liens to really speed up the process. So it is a slow, grueling process that takes weeks and months. And it's frustrating. It's frustrating for the client. It's frustrating for the lawyer, but it needs to be done before the lien can get paid. But again, ultimately, this is designed to protect the client, because the last thing you want to do is get your settlement proceeds and then find out weeks or months later that you have to pay back money to Medicare or Medicaid or some other entity because they had a valid lien that you did not account for before you received your monies. Okay. So just remember, the settlement amount and the amount that you take home are not always the same number, because there are these liens, statutory and medical liens, that need to be accounted for and which will ultimately affect the final distribution. To that end, it's important to tell your lawyer about every source of payment or benefit that you receive that relates to your injury. Okay, if you are receiving Medicare or Medicaid or workers' comp or health insurance, give them your claim number, give them a copy of your card so that they can write to the Medicare or Medicaid and ascertain what that lien amount is, because you don't want to have to start doing that after your case is settled. And quite honestly, the lien amounts are oftentimes used to leverage a better settlement on your behalf, right? Because those are hard numbers that need to be repaid. Okay, those are hard economic numbers. And you certainly want your lawyer to have them before engaging in settlement negotiations, because the settlement is going to the payment for the lien is coming out of the settlement. So you want to know what that lien amount is so that it can be taken into consideration in determining how much you might be entitled to. Okay, there's a case with $100,000 medical lien that needs to be repaid. Is everything else being equal is worth more than the same case where there's no lien that needs to be repaid. Okay, and a good personal injury lawyer is going to identify these liens sooner rather than later. Okay, and identify and figure out how much is owed, and take into account the lien amount when engaging in settlement negotiations. Okay, I hope you enjoyed watching this video. I know liens can be incredibly frustrating, confusing, and sadly they do oftentimes delay your receipt of settlement proceeds down the road. But understanding what they are and why they need to be repaid, hopefully that gives you a little bit of, not pause, but certainly maybe some understanding that it's not necessarily your lawyer's fault. These do take time. And I'd be remiss if I didn't mention, when there are sizable liens that can certainly affect how much you are taking home at the end of the day, there are actually there are actually companies that their sole purpose for existing is to help lawyers resolve these types of liens. That's how complicated they are. That there is a whole cottage industry of professionals who work night and day in helping attorneys identify these liens and getting them reduced for ultimately the benefit of their client. So again, Jonathan Ratchik, Kramer, Dunleavy, and Ratchik. Again, we help people in New York City and throughout New York State in personal injury matters. And I'm scratch that ending, Joy. I'm just going to say, I hope you enjoyed watching this video. Jonathan Ratchik, Kramer, Dunleavy, and Ratchik. Real bow ties, real results.